Thank you, Robert. Okay, next slide. What agreements are covered by the Massachusetts Non-Compete Agreements Act? The Act covers any non-competes from October 1st, 2018 through the present that are made in anticipation of or during the employment relationship. So before employment or during employment. And they're non-competes, so they prohibit the employee from engaging in specific activities that are competitive with the employer after employment ends. This includes both employees and also independent contractors under the three-prong test. Okay, next slide. What agreements are covered? Non-competes made in connection with separation from employment are governed by the Act only when the employee is not expressly given 7 business days to rescind. So again, the Act applies to non-competes that are pre-employment, during employment. It only applies to post-employment agreements that do not explicitly provide a 7-day revocation period. So as long as you put in a 7-day revocation period in a non-compete that's contained in a separation agreement, then you're out from under the restrictions of the Act. Okay, next slide. Non-competes are unenforceable against non-exempt employees, undergraduates or graduate students in internships or short-term employment, employees terminated without cause or laid off. So non-competes under the Act are not enforceable if you terminate someone without cause or lay them off. However, as we just learned, although you cannot impose a non-compete pre-employment or during employment, that will apply post-employment if you terminate the employee without cause or lay them off. Post-employment, you can put in place a non-compete at that point in exchange for appropriate consideration, as long as you give the employee at least 7 days to revoke. And you cannot impose a non-compete against someone who's 18 or younger. Next slide. Okay, more minimum requirements under the Act. It must be a written non-compete that's signed by both parties. It must expressly state the employee's right to consult with counsel before signing the non-compete. And by the way, when I talk about the non-compete, this can be a standalone agreement, an agreement with other restrictive covenants, or an agreement that's part of a general employment agreement, or even an offer letter that constitutes an employment agreement. Prior to employment, provided the agreement must be given to the employee earlier than the formal offer of employment or 10 business days before commencement of employment. And if the non-compete is provided during employment, it must be 10 business days before the non-compete takes effect, and you must provide fair and reasonable consideration, not just continued employment, for the actual signing of the non-compete or entering into the non-compete. This is separate from consideration for the obligation. This is during employment. If you ask an employee to sign a non-compete, you cannot just reward them or compensate them for signing that non-compete with continued employment. There must be some reasonable and fair consideration, such as a bonus, such as doing it in conjunction with a raise and promotion. Okay, next slide, thank you. More minimum requirements. This has to do with the scope of the non-compete itself. This is very important. These are some aspects that have been baked into the Act that were prior law in Massachusetts under common law, court-made law. The restrictions of the non-compete can be no broader than necessary to protect the employer's trade secrets, confidential information, and goodwill. So it's presumptively necessary only when the interest cannot be adequately protected by an alternative restrictive covenant. And this is something that employers need to think about. Your non-compete should be narrowly tailored, specifically to protect your legitimate business interests, your trade secrets, confidential information, and goodwill. And it must protect your legitimate business interests in a way that would be impossible to protect via another restrictive covenant, such as a non-compete or confidentiality or trade secrets agreement or provision. The agreement cannot exceed a 12-month restricted period post-employment. It can extend up to 2 years total duration in a situation where an employee breaches a fiduciary duty or unlawfully takes company property. It must be reasonable in geographic scope. It will be presumptively reasonable under the Act if the geographic scope includes the places in which the employee provided services, had a material presence, or influence within the last 2 years prior to separation. And it must be reasonable in terms of the scope of the proscribed or prohibited activities. Again, presumptions under the Act, it's presumptively reasonable if limited to the scope of the employee's activities within the past 2 years prior to separation. Next slide, please. More minimum requirements. All right, so this non-compete that's given pre-employment or during employment can only be enforceable if it is supported by consideration. The consideration should constitute either a garden leave clause, which we'll discuss in 1 second, or other mutually agreed compensation. And many people have asked me, well, I don't want to give a garden leave. I don't want to give that much consideration. What is other mutually agreed upon consideration? And at this point, the courts, although they've mentioned the Non-Compete Act, have not really delved into any interpretation of the Act. So we don't have any guidance with respect to what could be other mutually agreed upon consideration for the non-compete obligation. What I'm seeing and what I'm advising my clients to do is provide the garden leave. So what is garden leave? Garden leave becomes effective upon separation. It is pay that is equal to 50% of the highest annualized base salary within 2 years prior to separation. It is paid pro rata over the restricted period. So if you have a 12-year non-compete, you're paying it generally along with your regular payroll, unless the non-compete is breached by the employee, in which case you may stop paying, or you may extend the length of the non-compete and not pay for the extension. So as you see here in the bullet at the bottom right, pay is not required during an extension of the restricted period beyond the 12 months. And that extension would occur in the case of a breach of fiduciary duties, theft of company property by the former employee. Next slide. Okay, enforcement of non-competes. The courts have discretion to what we call blue line the document. So they can reform or revise to render the non-compete valid for protection of trade secrets, confidential information, and or goodwill. And this next one is very important and interesting. Choice of law provisions to avoid the requirements of the Act are unenforceable if the employee has been a Massachusetts resident or employed in Massachusetts for 30 days or more at the time of separation from employment. So if an employer employs someone in Massachusetts who lives in Massachusetts within the last 30 days of their employment, they cannot, through the contract, apply another state law so as to avoid the restrictions of the Massachusetts Non-Compete Agreements Act. Even if, say, the company is located in another state or incorporated in another state. And actions to enforce must be brought in the county where the employee resides or in Suffolk County by mutual agreement. If in Suffolk, in the Superior Court or in the business litigation section of the Superior Court specifically. Okay, next slide. These are the areas that are not covered by the Act. Non-competes that are made in connection with separation from employment. We talked about this already. When the employee is expressly given 7 business days to rescind acceptance. Non-competes outside of the employment relationship. Non-competes made in connection with the sale of a business or substantially all assets or ownership interests of the business. When the restricted party is a significant owner of or member or partner in the business entity. And when they receive significant consideration or benefit from the sale. These are non-competes that are outside the coverage of the Act. And one more slide, I think. The Act does not cover other restrictive covenants such as non-solicitations or covenants not to hire or rehire, covenants not to hire rather other employees, or for that matter to poach or to interfere in a relationship with employees. It does not apply to covenants not to solicit or transact business with customers, clients, or vendors, or interfere with those relationships. Does not cover confidentiality agreements, invention assignment agreements, covenants not to reapply for employment.